My name is Devin. Jasmine is here. So is Cameron, who will be leading today's session. So this is our second ever webinar. And Jasmine and I have been running OGO Strategy, which you may know us from our marketing agency for the past 4 years. And we just launched OGO Assembly, which is an online and offline meeting point for creatives and marketers. So because we're running a few minutes short today, I'm just going to get right into it and pass it off to Jasmine to introduce Cameron.
Yeah, we're so excited to have Kameron with us today. She is an attorney and the founder of Social Docket Dialogue with a background in employment litigation and over a decade in influencer marketing. She's on a mission to make legal strategy feel clear, empowering, and built for today's creative entrepreneurs. So, Kameron, I will hand it over to you.
Hey y'all, I am so excited to chit chat today. I'm going to share my screen. I love a PowerPoint, but please ask any questions as I'm talking and sharing down in the chat below. Let me just do I love the intro. That was so good. I'm always flattered. It's like, what do you do while people are congratulating you? Smile. So on top of employment litigation, I have really switched into influencer marketing contracts, which I absolutely love, but I still use a lot of my employment litigation background because as y'all know, y'all hire as talent managers, and it's a constant flow of a variety of different areas of law into one. And with that, let's see if I can share this. Now, I will tell y'all, okay, between us, I am an Apple girl and I'm on a PC because my MacBook went out. So bear with me 1 second. Let me make sure I'm gonna have to use the Google Slides. Listen, hey, we're making it do what it do today. Okay. PowerPoint. Everybody see the PowerPoint? Good. Okay, so contracts in the creator economy. So I feel like this isn't like a fun, cutesy, sexy topic, but I'm gonna do my best to make it fun, to make it lively, and keep y'all engaged. Again, please ask any questions, drop them in the chat, and we'll be checking that out. So here's a little bio about me. I'll send the slides so y'all we don't have to waste any time on me going through it. But like she said, I have 10 years of creator experience, 5 years of being a legal consultant in the creator economy, plus years of being an employment litigator. So all of those combined have brought me to Social Docket Dialogue, which is my legal education app, which we are relaunching in the fall, on top of having a consulting firm called The Legal Tea. So quick backstory about me. Here's social media platforms you can find me on. We'll talk more about that later, but I'm sure you're familiar with these platforms. If you're not, you should be, because the importance of being familiar with a variety of different platforms is it always comes back to the contracts. How does that connect? Because as we know, TikTok, is she here? Is she staying? Is she going? We don't know. So you want to be familiar with all platforms, even if they're new and emerging, because they may end up being the backup platform if you're collaborating with a brand, either yourself or on behalf of a client. So being familiar with a variety of different platforms are so important. It seems like, what would this have to do with contracts? But it means everything, because there's always going to be just a platform you may have to lean on outside of the one that you're currently partnering with. A little bit more about the Legal Tea and Social Docket Dialogue. Again, we'll cover this a little bit later. Okay, so jumping right into influencer marketing law. Why am I showing you the variety of different areas of law? Because whether you are reviewing a contract on behalf of your client and becoming familiar with the terminology, or you're hiring a lawyer, you want to make sure that it's a lawyer that actually understands what the heck is going on. So I do have to give a disclaimer. Although I am a licensed attorney, I'm not your attorney, okay? This is education and informative purposes only. However, making sure that you have professionals that are familiar with these areas of law, and there's so many others, is so important. Because again, it's really like this big ecosystem of touch points of a variety of different areas of law to get influencer marketing law, which is really a new concept in legal field and really in the creator economy as a whole. I know some of us, when we think of lawyers, we're like, I don't want to talk to a lawyer, or like, what did I do? Or it's negative. But in the influencer marketing context, it just doesn't have to be like that. Most of us that focus on this area of law, we're super down to earth. We're creators ourselves. We get it. And for me specifically, like, I really get it. I'm a boots on the ground, a creator as well. So when things come up, I can relate, not only practically and with my legal knowledge, but also as a creator and seeing how it practically works out in the industry. Here's a lot of contracts. Now, why am I showing you the contracts? Because if you are a talent manager, a lot of times you're either hiring in-house counsel, or maybe you may be using an attorney or a legal consultant like me to do some more complex contracts, but a lot of times you're familiar with the terms enough where you can review it enough to see what are the red flags, what are the green flags, Should my client sign this? Should they not sign this, etc. So this is just a little glimpse into the contract that may come across your table. You may see some non-traditional influencer marketing contracts, and that would be maybe like a model management or personal assistance, or even the motion picture rights, or like non-disclosure agreements. We might not think about those agreements when we think of traditional influencer marketing, but they come up. Why? Creators are now becoming a little bit traditional media. Not all the way. Hey, influencers are still, on the digital space. But the more we see it, we see a lot of our fellow influencers and creators in commercials, on billboards, getting modeling opportunities. And what does that look like? These type of contracts. So if you're a talent manager and you're trying to expand your agency and maybe kind of dip your toe into that traditional realm, being familiar with the terminology in these contracts will set you apart from your competition. First off, ain't no competition, but y'all know what I mean, generally competition. So being familiar with even traditional media is going to set you apart, and it's also going to be a benefit to your creators. And something, a little leg up you can do when you're trying to maybe pitch to a creator or broaden your roster because you have this knowledge. So don't be afraid to kind of dip your toe in other traditional realms of media. Okay, so before I jump into specifics for talent management agreements, I know that's what y'all here for. I did want to point out some non-obvious contracts. So this is a little outdated, the photos, but they're still super relevant in context. So some creators get the message that we see, NYX Cosmetics, oh, hashtag NYX Cosmetics. And you're like, oh my God, this is so great. Your client's excited. You're like, I love this. This is perfect. We can get exposure. Read the contract. So you're like, what is the contract? Where is it? The links that they provide, if you click that, if you copy paste it into your web browser, you're going to see a whole bunch of words on a document. That's a contract. A lot of times when we think of contracts, we think, oh, it's a Word document, it's a PDF, you have to sign it. There are so many other ways that we are really signing agreements with each other without it looking like a traditional contract. So making sure that we are aware of what the terms say before we let our clients sign these agreements or say hashtag yes or hashtag yay or whatever the case may be. That also, again, lets you be in a position of educating your clients and educating creators to set you apart from other managers and other agencies. So being aware that this happens, so you know, what does the term state? What is the usage rights? What is the exclusivity? Is my creator ever going to be able to work with them and get paid for it? Things like that are so important in a non-obvious contract like this. Okay, another non-obvious contract, which, listen, hey, I've done it. I try to read them now. Now I stay on top of it because I try to educate on it. But the terms and conditions. We all get that email, okay, from any platform when they update their terms and conditions and the privacy policy, and we're like, okay, anyway, unfollow, block, spam. But it is important to read it because compliance a lot of times is embedded in that. And what I mean by compliance is, as influencers, as creators, when we post our brand partnerships, there are a few things we have to do. For example, on Instagram, we have to turn on our paid partnership symbol and make sure that our hashtags are in order and things of that nature. You find out a lot of that information in the terms and conditions, and platforms change over the years. Another example is on YouTube. There was a big case about like children on YouTube and vloggers and family content. Child, that's a conversation for another day. But they changed it where you had to make sure you turned it on or off if it was meant for children or not meant for children. That was because of a lawsuit that happened. So us staying on top of terms and conditions of platforms, we are able to educate influencers and be educated ourselves with how to use these platforms efficiently and effectively. I'm not gonna lie, I'm a little nerd when it comes to some facts. So I just included this because I thought it was interesting. So essentially, it just shows different facts when it comes to like live streaming, because that's something that's starting to really elevate this year in the influencer marketing space. It shows how often long-term influencer partnerships are being focused on, 47%, which I think is important for us to know, and also gives us a level of encouragement to really pitch long-term deals when it comes to our clients and creators. So I think that's just super dope. Then, of course, as we all know, it's a billion-dollar industry that just keeps on giving and giving and giving, and it doesn't look like it's slowing down anytime soon. I will also even add, a lot of my clients, myself, and fellow colleagues have noticed there's been a little bit of a decline in the brand partnerships, but I want y'all to know that One small decline is going to be increased later. Think of like 2020, when in the beginning, everyone's a little uncertain, like what the heck was going on. And then about midway through the year and up, everyone was really growing online. And I anticipate that happening this year. So just a little bit of encouragement to know, hey, keep on going. This industry isn't going anywhere. And the predictions are constantly elevating year after year after year. Okay, terminology. Now listen, I was going to try to make it cute, put some little extra things on there to make terminology is terminology. I listed a lot on here, and there, of course, are so many other terms that I believe that we all should be really aware of, such as brief. So this is going to be when a brand provides a guideline, they usually term it as a brief for you to be able to review. What does this have to do with contracts and law? In that brief is another level of compliance. So the first level I talked about was going to be on the social media platforms, turning on the paid partnership, making sure that you're abiding by whatever that platform's toggles and features that you have to turn on are. The second level is going to be the brief, the brand guideline. They usually say, hashtag brand partner, hashtag ad, hashtag whatever, or they provide you specifically what you need to do to abide by that brief. That's the second level of compliance. The third level is going to be the FTC, which I have listed here, the Federal Trade Commission guidelines. This is going to be that third level of compliance that you want to make sure that your influencers are really abiding by and understand. And you can easily find this. Google FTC influencer guidelines. They have an amazing PDF that really breaks it down. But one of the things, for example, is you need to put hashtag ad or hashtag partner above the fold. So above the fold is going to be, instead of clicking show more, because we all see it show more and we're like, is this an ad? Is it not? It shouldn't be a question. And I really bring this up because there is a lawsuit that is currently going on. It's consumers that are suing Revolve and influencers. As an agent and as a manager, you're like, I don't want my creator client involved in any of that. So I always emphasize making sure that you're being compliant in those three levels: social media platforms, that brief, and the FTC guidelines, to hopefully avoid some of these unnecessary litigation matters. I think this is one of many coming down the pipeline, because as influencer marketing elevates and grows and people really start to see, oh, this is a billion-dollar industry, law is going to want to get involved and regulations are going to want to get involved. And unfortunately, like, law and the creator economy are so disconnected that my fear is that it's just not going to be good at first. Law is not going to get it right. A lot of times they don't. So I'm trying to do my best to really focus on educating everyone on all sides to make sure that we can do our best to avoid any of that. Other terminology: deliverables, usage rights, whitelisting. Definitely comment in the chat. I'm going to leave some time for Q&A, but definitely comment in the chat any of these terms that are unfamiliar, and I'd be glad to really deep dive into it. Most of these are probably familiar to a lot of us. A few I want to point out is exclusivity. That simply means like non-compete. You see, I have non-compete separate because it's a little bit different depending on the contract. But what I will say is perpetuity and perpetual use means forever. 9 times out of 10, there are every once in a while, but 9 times out of 10, they should not be in any influencer marketing agreement. You really don't need it, even if it's a contract between an influencer and an agency. You really don't need it there either, because usage rights really should always be limited. When we think of terms as usage rights or exclusivity, etc., like, we want to focus on limiting that duration. And the reason behind it is we want time to have a discussion later on. So, for example, if you're having an agreement between you as an agency and an influencer, you want to make sure that usage right is limited, because let's say y'all terminate the agreement early. You really don't need the ability to have their name and their likeness, etc., only during the time that they're working with you. That doesn't mean you can't use it for internal purposes, which is something you can add. Doesn't mean you can't use it for like business strategy, internal purposes, but you definitely want to make sure you have limitations on exclusivity. Don't use perpetuity usage, and a variety of other terms. Another term I do want to point out here, there's so many, is work for hire. This tends to be slipped into brand partnership agreements, and it just is not applicable. The only time this works is with UGC, which is user generated content. Let me explain what work for hire is. Essentially, it's if I'm working with a brand, the argument is the only reason I would be creating this content is because the brand hired me, right? Which makes sense. Like, if it's a brand partnership, the only reason I'm doing this brand partnership is because they hired me. However, if I have to post it on my social media platform, the argument doesn't work, because I can post on my social media platform with or without the brand deal, right? Like, I have access to post on my platforms whenever. So work for hire doesn't apply if I have to, as a creator, have to post it on my platforms, because I can post with or without the brand deal. However, if it's only being posted on the brand's marketing, yes, it's work for hire because I don't have access to the brand's marketing without them hiring me. So that's a little bit of a nuance there. It slipped in the contracts. It really just isn't needed. I do see some questions in the chat, so let me bring up some of these. Ooh, curious to learn more about the kill fee. I love this, and I feel like it needs to be in pretty much any and every contract. Again, I hate to do this. I feel like as a lawyer, one thing about me is it's always going to be it depends, because there are situations where it just wouldn't be applicable. So essentially, a kill fee. I also should have put late fee in here. Pro tip, please, I'm begging y'all, put late fees in your brand partnership agreements. And if a brand says they don't agree to it, be like, well, if you don't intend on being late, then what's the problem with a late fee? I don't know. It's just me. Okay, so a kill fee. I have a list of terminology. I should have put the definitions on here, but y'all, the slides was getting long. So I was like, let me not include my little bootleg definitions. So essentially a kill fee is, let's say, for example, I'm partnering with brand A, and in the middle of the campaign, after I've already created the content, I'm currently in the middle of editing, they just shut down the whole campaign. I'm sorry, what? As a creator and as people that work with creators, you know, time is limited. If I spent all of those hours, or even if it wasn't that many hours, but time is still money, okay? Let's just keep it real. I should be able to be compensated for something. So essentially, a kill fee is allowing the brand, sure, hey, we weren't able to do the campaign. Maybe it's something that happens in society, or maybe it's just like a conflict that happens, but this still allows the creator to get some type of compensation, but it also allows the brand to not to pay everything in its entirety. So it's really a win-win on both sides, where the brand is still going to pay something because the creator did put in work. Maybe they said no to a brand deal because of this current campaign, because of exclusivity, right? So maybe it's not even about the time that they put into the campaign. It's about them saying no to other options during that time. So a brand you can negotiate either a fee at the phase of the contract, which I think is smart. Negotiate everything you can in the beginning. When I think of a contract, it's like in the beginning, everyone's happy. They're excited. They're like, yay, everything's nice. So you don't want to have to negotiate when everything goes wrong. Now, even if it goes right, it's still tense later on. It's deadlines and maybe someone's unhappy. At that point, the goal is to just point to the contract when everybody was happy. So you want to say, hey, you know what? Page 2, paragraph 3, remember when we were happy with each other? Let's just talk about that. So the kill fee is beneficial just to make sure everyone's comfortable. And again, it's almost like, hey, sometimes things happen. We get it. We're not trying to take all of the money, but I want to get paid for something. Let me see. I know there were some other questions in the chat. Derivative works. Ooh, okay. I love this. Great question. So derivative works essentially is, let me take a step back. We have licensing and we have usage rights, right? So licensing, I like to think, is the type of cake. So I like marble cake. I know that's random, but that's what I like. Licensing is the type of cake. So it's not as broad as usage. So licensing could be a limited license. You get full licensing rights. And then there's other nuances with licensing, but usually it's limited or you get full licensing. So the type of cake is your licensing. Usage rights is the decoration on that cake. So usage rights is really going to get into the how, the when, the where, the etc. of that license, of that cake. So where derivative work comes in is with the usage. So you're saying, okay, well, let's do a limited license to use my content. But what type of usage? You can use it on Instagram. You can use it for 30 days. But derivative work says how you can use that piece of content. Can you edit it? Can you add sound to it? Can you add text to it? Can you post it in a different format? So derivative works is really going to say how the brand can shapeshift that content, or if they can at all. Usually it's fine. Like, for example, if you're trying to go from like Instagram to TikTok, there may be just like a slight difference in like a measurement, or like from stories, like, you know, just a slight difference, that's fine. But when you're talking about text, sound, audio, etc., that's where you might want to limit it, because we would not want a brand to misuse our content, right? We don't want them to shapeshift our thoughts and our ideas on a piece of content. But of course, we want to give them a little flexibility to make sure that it, you know, it applies to the platform that they're using it on, things like that. Great question. Perfect. I'm gonna go to the next slide. Okay, so before I answer the next question, let me just do a quick overview of this is what your contract should look like. Now, wait a minute. This is just the term. These are the headings, okay? There's more words to the please. There's more words to the contract. But essentially, this pretty much covers every talent management agreement. This right here. And then, of course, you have the fill-ins with further descriptions of these headlines. Are there other headlines you can use? Sure, but this is the general gist of every talent management contract. These are the clauses. Term, explain how long. If you have a renewal fee, it should a renewal term, also add that in there. If you have an initial term, if it's your first time working with a creator, I'm going to suggest always have an initial term. The initial term, when I consult with creators, a lot of times I'm saying, hey, you want it to be limited, but you want to give them the chance to show you why they are the agency for you, right? But also, as the agency, you want to see if this creator is even somebody you really want to work with. Because a lot of times we see a creator, we're like, oh my God, I love them. They're the dream client. And then when you actually practically work with them, maybe it's not ideal, right? On both sides. So don't look at a creator requesting limitation on the initial term as a negative. It's really a positive on both sides. It's a win-win for everybody to give people a chance to get to know each other. Termination. Everyone wants a way out and needs a way out. Things happen socially, there's scandals, there's all types of things happen nowadays, okay? So everyone should have the ability to terminate the agreement within reason, okay? You don't want somebody just to get signed the contract, you start pitching them, all of a sudden they terminate. That's wild, right? But I added the buyout here because this has been a game changer with my clients and with other agencies that I've worked with. Let me put it into a practical situation. So let's say you're working with me as a creator, you're my agent, and you're my manager. Let me use terms correctly because there is a difference between agency and manager. An agent and a manager. Agencies tend to be, kind of interchangeable, but agent and manager tend to be different. But let's say you're my manager and we are under a year-long contract. Yay, I'm so excited. You're the best. I'm so excited. You're getting me deals, period. Then about 6 months in, I'm like, you know what? I don't know what, I want to work with somebody else. It's not you, it's me. I'm the problem. Okay. We're breaking up. 6 months in, I have no problem with terminating. But the problem is I signed a 2-year-long contract with a brand. So you as the agency have the right to get 20% up until the end of that. Naturally, right? Naturally, that's what you deserve. A buyout fee will allow both of us to walk away for a fee. So instead of me saying, okay, I'll give you 20% for the next 2 years, and it's like, we don't really even want to talk anymore, and I have to pay another agent, I'll be able to pay you a lump sum, a buyout fee, in order for us both to walk away. So definitely consider that. It could be 50% of the total outstanding fees paid within a certain amount of time. It could be 30%, etc. But I do think that should be something that should be added. Services, explain everything. Payment terms, make sure this is clear. Are you accepting the money? Are they accepting the money? When do you pay them back from that acceptance of the money? If a brand is late, how does that work? You want to make sure any scenario you can think of is pretty much spelled out in the contract. I also want to add this. It doesn't have to sound super legalese. Like, you don't have to therefore, moreover, all. A contract is a contract is a contract. Simple terms tend to work better. We don't want super ambiguous terms or things that are too broad or we don't really understand. It's okay to keep it simple. Add a few little legalese if needed. I'm not saying don't add like jurisdiction, choice of law, things like that, arbitration clauses. But when it comes to just like services, explaining what the creator needs to do, what you need to do, it can be very simple. Like, what do you intend on providing to your clients? What do you intend for them to provide to you as far as being ethical and being timely, et cetera, to make sure that both parties are being professional? Ownership and usage, kind of touched on that quite a bit. Responsibility or representations and warranties. This really just deep dives into the client is, over 18 or they have a guardian, like who is able to enter into the agreement and what are the expectations. Indemnification, I want to bring this up. Generally, this is what this looks like. If I'm partnered with brand A, so Cameron and brand A are in partnership, Susie can't come whisper in Cameron's ear to sue brand A, and then Susie can't come in brand A ear to whisper to sue me. I can sue brand A, okay? But third parties can't come in and have us go against each other. That's what indemnification is essentially saying. With agency contracts, super important. You want to make sure after this agreement is signed that you are on the same page. So indemnification is not allowing third parties to come in and interfere with what you got going on, okay? And then most of these other terms are pretty familiar. Non-disbursement. Let's not talk bad about each other. Okay, I'm not gonna talk about you. Don't talk about me. Okay. Jurisdiction and choice of law. I always say naturally you're gonna want to be in the state and the jurisdiction in which you live in, and or what your company is, your entity is formed. Breach and remedies. This is gonna set out what does the breach look like. Okay. Again, doesn't have to be super fancy terms. If you don't respond within 7 days, that's a breach. If you don't, you can determine what that looks like. And of course, like there's going to be insinuations just embedded in the contract because that's what law does. But you can get really detailed on what would be a breach for you, what would make you feel uncomfortable as the agency. Arbitration, arbitration, arbitration. Please have an arbitration clause. It's cheaper, it's quicker, it's less of a hassle. You still get money if they breach the contract or vice versa. So having an arbitration clause is actually a green flag, not a red flag. Power of attorney, you need this. You need a power of attorney, usually as an addendum attachment, if you're going to accept the money on behalf. Also, you're representing a client. So you are holding yourself out to be representation for a client. You need them to sign a power of attorney. Code of conduct. Some agencies have it, some don't, but I think it's just nice to have, again, kind of helping with that breach of contract terminology. If you have certain standards you require of your creators, hey, no swearing, I don't know what, no discussion of XYZ, we require you to be timely and whatever your code of conduct is for your clients, you want to make sure that's also in the contract. Again, we're trying to think of everything in the beginning and the fun, yay, so we can just point to it later when everybody's mad. But hopefully it doesn't get that way. Okay, these are just quick red flags. I'm gonna just breeze over these. Unwillingness to negotiate contract terms, it's a red flag. It's a Word document, it's a Microsoft Word. Please don't allow someone to tell you they can't edit a Word document, please. It's a lot, okay? Overly broad terms. It needs to be clear. Limit the duration. Where is this going? How long are we working together? When can we terminate? Very, very clear terms. One-sided terms. If everything says agency can do this and nothing creator can, it's a red flag. Creator can do this, agency can't, red flag. Sole discretion of brand or sole discretion of anybody, there really isn't a situation where there shouldn't be a negotiation unless the terms are clear already on it. So you want to make sure it's broad enough for both parties to have some type of say so. The only time this may be relevant is with strict ownership rights, where a creator has the sole discretion to determine how their content can be used and their intellectual property can be used. Contract terms do not reflect email negotiations. I know we've all seen it. You go back and forth with a brand, you get to the contract, and then it literally says like the rate is $10,000 and we just discussed it's 20. Like, what's happening? So making sure that the contract terms and the negotiations align. So double check that. And then also vague content approval process. This may seem kind of random or minor, but this is huge because what happens is all of a sudden 20 weeks go by. Okay, that's a bit dramatic. 20 days go by. Okay. And then the content approval process is not clear. And you're like, hey, when are you going to get back? And they're like, oh, we're still reviewing. We're still reviewing. And what does that do? Push the payment timeline back. So make sure it's clear. Of course, give some flexibility. Naturally, this is the industry that is forever changing. But let's start with a little bit of process. Okay, so just really quickly, this is just my little spiel where I feel like there's a disconnect between influencers and lawyers. Please talk to someone if you need help. If you don't understand, just ask. It's better to ask beforehand than to sign it and then ask later. I promise. There's always a loophole usually, but ask. It doesn't have to be this scary disconnect between law and the creator economy. Okay, I threw in some AI stuff. Again, I'll share this so that they'll be able to provide it to y'all, but don't be afraid of AI. Use it as an assistant. Use it as a tool. It is not a replacement. It is not a replacement. It is not a replacement. It is a tool, but you will be replaced if you don't learn how to use the tool, because what's going to happen is people are faster. That's the name of the game. It's going to be faster. I just thought there's some interesting stats about how AI and influencer marketing are starting to integrate. It says AI integration improves campaign outcomes by 66.4%. That's crazy. And how is it? Because it's faster. I'm telling you, the name of the game is how fast someone does it. Somebody literally told me a lot of times it's not about intellect. It's not about strategy. Somebody just did it faster. And sometimes when you do it faster, even if you get it wrong, you learn faster. So don't be afraid to use AI and other tools to just make your business more efficient and effective. Here's some places where you can find some information about influencer marketing and social media law. So Social Docket Dialogue, we are in the process of relaunching. So please join the waitlist if you guys are interested. It will be an all-in-one legal education and consulting platform for creators, influencers, and marketing professionals looking for terminology descriptions. So a community where we all can really just discuss and hit the nitty-gritty about everything. Also an area where we can get a summary of these terms and conditions and privacy policies instead of us reading it, okay? So just a really all-in-one. Of course, we'll have video content because I'm a YouTuber first, so I love video content, and I think that's just the best way to communicate a lot of things. Quarterly master classes, and we also will plan on integrating AI in a variety of different ways. with compliance, hint, hint. So stay tuned for that. The FTC is super important to me and to this industry, so definitely stay on top of what they have going on. Business Insider, it's all in one, okay? Forbes is great too. And then American Influencer Council. If you don't know who they are, you need to know. The AIC is amazing, a plethora of resources for creators and marketing professionals. So follow them on Instagram, connect with them, stay in contact with them. They are, I think, one of the top 5 places that I always go to when I need information. Here's a little about me. I know we're running out of time, but definitely stay in touch. You guys have any questions? Here's my email. It's hello@CameronMonet.com. It's on all my socials. All of my social medias are Kameron Monet. LinkedIn is Kameron Buckner. That's my government first and last. Okay, fun fact, Monet is my middle name. But here's where you can find me. And I did see another question in the chat, so I'll go ahead and answer that really quick. What legal tools or practices do you think every marketing team should have in place, no matter their size? Oh, I would say a terminology vault. So as you come across different terminologies and you deal with different brands and creators, having your description to explain to you and your team what this means makes a ton of a difference when it comes to negotiating. Because if one person thinks it means this and somebody else thinks it means that, there's not alignment. So having a termination vault is going to help with negotiating, with pitching, with everything.
Amazing. Thank you so much, Kameron. This was fantastic. And to everyone that joined us today, we'll be sharing the recording as well as Kameron's contact information. So thank you so much, everyone.